Welcome, everyone. My name's Emily Broad-Lieb, and I'm a clinical professor at Harvard Law School and the director of the Food Law and Policy Clinic. I am so delighted to be here today to welcome our incredible panel. I want to briefly introduce the Food Law and Policy Clinic. We are an experiential education program at Harvard Law School focused on educating students about the laws and policies regulating the food system and providing direct legal and policy assistance to organizations and government agencies in this space. We've been actively teaching about, thinking about, and working with partners, including many of today's speakers, to address historical and present racism and systemic discrimination in the food system. We've taken a particular focus on discrimination faced by Black farmers who've lost hundreds of billions in land value and income since 1910, in large part due to federal policies, many of them implemented by the US Department of Agriculture, that were designed to drive them out of business. Earlier this year, the Food Law and Policy Clinic supported efforts for Congress to include in the American Rescue Plan $4 billion that was intended to go to debt relief for socially disadvantaged farmers and ranchers, those farmers who have faced such discrimination. And we watched in shock and disappointment at the fallout in the courts as a result of this legislation. So we actually have a really, truly all-star panel here today to talk through the challenges, this legislation, the litigation, and where we might go from here. So I'm really glad to have so many people joining us today for this conversation. And I want to give a few thanks and then introduce our moderator who'll take it from here. So I want to give first a huge thank you to Nate Rosenberg, who's a visiting scholar at the Food Law and Policy Clinic, and Emma Scott, who's a clinical instructor at the Food Law and Policy Clinic, for doing all of the hard work of organizing this event. I want to thank the Counter for co-hosting our event and the Harvard Law School Mississippi Delta Project for co-sponsoring. As far as just housekeeping quickly, there's a Q&A function at the bottom, so you can enter questions there, which we'll get to at the end. And we are recording this event so that we can make it available to all of you and to other interested parties in the next few weeks. So without further ado, I'd like to introduce our moderator, Sophia Charles, who is an Alabama-based journalist who's spending a year covering Black farmers and agriculture in the US for The Counter, which is a national publication about the business, politics, and culture of food. Thank you so much, and I'll turn it over now.
Thank you so much, Emily. I would also like to thank Harvard Law School's Food Law and Policy Clinic for organizing this event and for co-hosting this event with us. And of course, our wonderful and extremely knowledgeable panel that's gathered with us today to discuss this extremely important topic, as well as the listeners who have taken the time to be here and to engage with us. So thank you. Now let me get to our panelists. With us today is Lawrence Lucas. Mr. Lucas has worked at USDA for 37 years before retiring in 1996. Since then, he has devoted himself to civil rights advocacy through the USDA Coalition of Minority Employees, which as president and now president emeritus, he has helped to transform it into one of the most provocative, creative, and diverse civil rights employee organizations in the history of USDA. Lucas also represents the Justice for Black Farmers group, which he co-founded in 2019. We also have Tracy Lloyd Mccurdy. She is the co-alchemist of the Acres of Ancestry Initiative and Black Agrarian Fund, as well as the co-founder and executive director of the Black Belt Justice Center, a legal and advocacy nonprofit organization dedicated to the preservation and regeneration of African-American farmlands and land-based livelihoods. And finally, we have Keisha Stokesha. She is a senior supervising attorney with the Southern Poverty Law Center's Economic Justice Project. Originally from Jackson, Mississippi, she graduated from Jackson State University in 2006 and Harvard Law School in 2009. She currently resides in Montgomery, Alabama, with her husband, Robert, and two children, Robin and Roman. It is a sobering reality that over the course of the last century, African-American farmers have been stripped of their livelihood and land, a precious heirloom they hoped would seed a new generation of Black farmers. This has been in large part due to federal policies implemented by the US Department of Agriculture. Despite sustained pressure from farmers, advocates, and reformers, the department has yet to remedy the disastrous effects of well-documented racism and discrimination, both within its agencies and through its policies, as evidenced by the latest barrier to reparation, Congress's debt cancellation program for farmers of color that's currently held up in the courts. Our panelists will discuss the USDA civil rights track record, as well as the current fight for debt relief to Black farmers and the legal issues at stake. To kick us off, we're going to play a short trailer before we hear from Mr. Lucas and the rest of our panelists.
I lost my livelihood in farming. I couldn't farm. They took away the one thing that I really loved, and that was farming. That's what the USDA did.
He showed me a big tarp that had the words on it, nigger, go home.
The lack of commitment by too many people to not really caring whether we did justice or not.
Even as long as it's been, we've experienced discrimination for a very, very long time, and most people would have given up. To this date, I haven't given up, and I never will give up, until justice is served.
That's what my daddy would always say. He says I wasn't in trouble or anything. Everything was fine until I went up to defend my dad. And he says, what was I supposed to do? He says, I'm a man, and that's my daddy. I'm supposed to defend him.
He said, don't let USDA take my land. It was like anybody else, but just don't you let them have it. And we've done that. Nobody else has taken it either, but for sure the USDA will never get it.
Quite frankly, I say that the United States Department of Agriculture murdered them, my mother and father, and my brother.
My name is Lawrence Lucas, and I'm pleased to be a part of this very distinguished panel. But first, I want to thank Harvard University, Law Policy and Politics of Debt Cancellation, and the Harvard Law School for having this panel today to talk about the issue of the abuse, the racism at the U.S. Department of Agriculture. I want you to know that for some 20 years after meeting in the White House with John Boyd, Phil Haney Sr., and President Al Gore, talking about the framework that is needed in order to address this issue of discrimination and racism at USDA. The fact that so much land has been lost, the fact that so much wealth has been lost, so much and so many lives have been lost because of the indignities and the abuse at USDA. What I'm trying to do with the trailer is add some, or put a human face on the problem, not just hear it from us, but understand and know what you saw on the trailer is just a small piece of the pain and suffering that Black farmers have suffered in this country at the hands of USDA. Black farmers, when there were millions of Black farmers. And we also had millions of acres of land. And I'm sorry to say that if it were not for the US Department of Agriculture, many Blacks in this country would now own thousands, if not millions of acres of land. And there would be more Black farmers able to survive. And one thing most important is that they are denied the opportunity to pass on the wealth that could have been gained as they collected and bought land and took care of their families. Department of Agriculture took their land, took a way of life. They took the wealth. We lost 90% of the land that was owned during Reconstruction. We've lost it over the years, and we've lost it because of racism at USDA. Was no accident. It was all planned. Very well-planned scheme by the privilege to maintain what they had before and during Reconstruction. Black farmers have been victimized by systemic land theft since Reconstruction. And what do we think needs to happen? What we need to have is a transformation of a culture at USDA that would give Black farmers debt relief, that will give Black farmers no abuse of foreclosure, that will give Black farmers the same opportunity and programs that white farmers get in this country. I'm sorry to say that many of us think that what is needed is reparations. I say it's justice. And if we don't ask for it now and get it now, why not? Our group that asked for debt relief for Black farmers was told by the VILSAP transition team that what we were asking for, and I want to say thank you to Tracy Mccurdy, who kept us on track, who made sure that we did not forget the legacy Black farmers of Pickford. We were told that what we were asking for Black farmers was unconstitutional. Strangely enough, we had others to disagree with them. I want to say, if not for Senator Elizabeth Warren, who we sat down and talked with, and her staff when she was running for president, she was told that the reason why Black farmers were losing so much land in this country was because of air property. That is incorrect. We were able to sit down with her and talk about the pain and suffering of Black farmers. She talked to Black farmers, she talked to advocates. And she, in turn, changed and turned to a different course. And that course was to see to it that she would come up with a plan that would be deserving to Black farmers. I want to thank, if not for Elizabeth Warren, we would not have the Justice for Black Farmer Act. I want to say thank you to Cory Booker, who put that on the table to be passed in the Congress in 2019, 2020, and now in 2021. And he plans to pursue the rights of Black farmers again in 2022. I want to say thank you to Reverend Raphael Warnock, Senator, who also came to our cry for help. And this is the one reason why, and Stacey Mccurdy, who's on the phone, will explain and tell you more. about the details that exist around what we are fighting for now, which is systemic change at USDA. We want systemic change and we want it now. We don't only just want it for farmers, but we also want it for employees. So often we hear about women being raped, women being sexually abused, women being retaliated against, women being fired for speaking up, for coming to Washington and testifying about all the sexism that's going on at USDA and other abuses. So we have a bigger challenge, the Coalition of Minority Employees and the Justice Black Farmer Group, to deal with now the systemic abuse that is still going on and still being experienced by employees. Accountability at USDA is a must. Reconciliation process is a must. Transparency of what is going on at USDA is a must. The settling of Black farmer cases in the thousands, the settling of employee cases in the thousands. We have, the Counter did a story that Stuckey and Rosenberg did a deep dive into what's going on at USDA and found out that many of the allegations of success by the Vilsack administration during Obama were nothing but successful and beneficial to farmers and employees. The report in the Counter contradicts, and I want to thank Bryce Stuckey and Nate Rosenberg for bringing to the attention, and I think they called it the 5 myths that USDA claims that they had done such a good job on civil rights, and that is not true. I want to say thank you to all those courageous employees. I want to say thank you to the advocates who still now challenge what is going on at USDA. Accountability is one of the most absent pieces and what is needed to change the systemic discrimination at USDA. You can't solve the problem by solving a case. You can't solve the problem by solving a case for another class of people. But you have to look at and take a deep dive into USDA and demand that USDA becomes an agency that is not abusive, an agency that treats farmers fairly, an agency that will investigate their cases, an agency that will not let the Office of General Counsel, OGC, control the civil rights process, the same agency that supports and is responsible for representing the department in court and around the country, and they have the same responsibility to deny, and given the responsibility to this day, to deny employees and farmers their just due in settling their cases. The one thing that we always talk about is the county committee system. There's, in the process now, they have an equity commission that's talking about what they can do to change things at USDA, but it's controlled by the Secretary of Agriculture. They're not gonna be meeting and come up with a report, and their findings will not be available for us to see until 2023. We can't wait that long for Black farmers. We can't wait that long for employees. We want change, and we want systemic change at USDA now and not later. If not now, when? If not now, why not? What I want to say to you before we get into the question and answer period, and I'm thankful to have my colleague to clarify some of the things that I just briefly touched on. And I trust that Tracy Mccurdy will do just that. The U.S. Department of Agriculture has a reputation for being one thing, and that is it has a reputation for mistreating its people, and it's the worst agency in the federal government. USDA has a reputation, and that reputation is that it is called the last plantation. Most duly awarded that reputation because of the way it has treated for decades Black farmers, stolen their land, stolen the wealth that could have been passed on to other generations. I want to say thank you, Harvard, for having the courage and the tenacity for the many reports, 2 reports that I remember, and studies, for taking a deep dive into USDA. And your reports and the Counter and other publications, Politico, that are now looking at this agency. And if not for the advocacy of groups like the group that Tracy Mccurdy represents, thanks for the group like Tillery, Gary Grant, thanks for Rod Bradshaw, Eddie Slaughter, thanks for Michael Stovall. Thanks for so many farmers that are willing to still fight an agency that has the power and the political wherewithal to destroy other people's lives. We want to change that. And Harvard, I think in your studies, the 2 studies that I've read and the articles by Stuckey and Rosenberg clearly indicate that there's a new narrative in town, and that narrative is justice. That narrative is that we want something better for America, and we can only do it if we work together. We can only do it if we bring justice to USDA and justice to the many thousands of farmers who've lost their land and have lost their wealth. Thank you.
Thank you so much, Mr. Lucas, for your remarks and grounding our dialogue in this history of anti-Black racism that has contributed to 90% of our land holdings being diminished as Black farmers and Black agrarians. I too am deeply appreciative that Harvard has created this community space for us to engage and to discuss. I really want to pick up the thread of the politics of debt cancellation. And I think that it's very important that we name it debt cancellation instead of debt relief. Because when we talk about debt cancellation, we are talking about our Black farmers' 30-year, well, we have to go back. Again, there are various timelines of dispossession. So when we talk about debt being used as a tool of racial oppression, we can look at the outgrowths of chattel slavery, which was sharecropping and tenant farming. And I'm reminded of grandfather Hillary Thomas Stewart Jr. He was George Floyd's great-great-grandfather, and he was born at the end of slavery. During Reconstruction, he acquired over 500 acres of land in North Carolina. White farmers, through criminality and collusion, stole all 500 acres from him, stripping him of his economic independence. George Floyd's grandparents later toiled as sharecroppers in North Carolina tobacco fields and were never able to climb out of the cycle of debt to acquire land again. And so when our elder farmers refer to USDA, the last plantation, it's very important for us to understand how debt was used to dispossess and exclude Black farmers of their land. The other tenets of, I think, USDA, the last plantation, and I don't know if we will be able to explore that during this community discussion, is our position as a coalition, and we work very closely with Justice for Black Farmers Group, and we appreciate their leadership around the abolishment of the county committee system. That's another column of USDA, the last plantation. One of our farmers, Carl Parker, who's a legacy farmer from Ashburn, Georgia, talked about how his father served on a county committee there. And then years later, when he applied for a loan, that same county committee refused him a loan, and that night he had a heart attack. So that's the second column, abolishing the county committee. It is still an apparatus of oppression that is used to undergird and support white farmers while neglecting farmers of color. And particularly, it still has that venom of anti-Black racism. The third column of USDA, the last plantation, that we are deeply focused on is applying a restorative justice lens to the Commodity Credit Corporation Fund. And I don't know how many of our listeners remember this article came out in the New York Times back in 2020. And it revealed that at the time, President Donald Trump was funneling up to $46 billion through the Commodity Credit Corporation Fund to shore up white farmers and his political base. He even carved out another $100 million specifically for white farmers growing tobacco in North Carolina, a battleground state. And so one of the issues that we have raised with Secretary Thomas Vilsack is that what are we going to do during this third tenure as Secretary of Agriculture to dismantle the inherent inequity of the Commodity Credit Corporation Fund and how it could be used to restore the Black agricultural land base. So I really wanted to lift up those three tenets of the columns of USDA, the last plantation, that we are determined and working mightily to destroy and dismantle. I would be remiss if I did not talk about the thousands of Black farmers that have ascended to ancestorhood without restorative land justice from USDA. Thousands. I want to lift up Brother Eddie Wise, who, when you study Black agrarian history and Pigford specifically, Brother Eddie Wise and Dorothy Wise, they were fierce advocates, and they advocated and they illuminated the deep anti-Black racism that was the rot within USDA. They were light bearers in the Pigford v. Glickman class action racial discrimination lawsuit. They filed they wrote a letter actually with Judge Paul Friedman at the time opposing the consent decree because they knew that it would be result in massive land loss. And so I really love the title. I really want to lift up the director, Sean Hill, and Dr. Wayman Henson with respect to their documentary film, I'm just a layman, a layperson fighting for justice. And I think it's really important when we had this conversation about where we are, this historic moment. Our farmers have been fighting for this since 1983, when President Ronald Reagan dismantled the Office of Civil Rights. Eddie Wise and Dorothy Wise, they later would have their debt accelerated. And they were actually foreclosed on during the Obama Vilsack term. Dorothy Wise, the next year, she ascended to the land of the ancestors because of the turmoil and the despair and the severance of this land lineage. Eddie Wise ascended earlier this year. And what is so devastating is that Senator Cory Booker lifted him up and the story of the Wises as justification for the American Rescue Plan Act and the Emergency Relief for Farmers of Color Act. So where are we now? I felt a little bit melancholy today when I think about the fact that when you study the Pickford lawsuit, we started out at the time, there were 22,000 Black farmers that filed claims against USDA. And because they were so poorly represented by counsel, that the process reeked of attorney malpractice, incompetence, that 7,000 Black farmers were denied outright because the attorneys for the Black farmers negotiated away discovery. And Keisha's going to go into the importance of movement lawyering and litigation. And so I think it's really important because oftentimes we talk about what happened presently in the courts with this regressive conservative posture of the courts, but we don't want to talk about what happened to Black farmers under the appointment of a Democratic, a judge that was appointed by a Democratic president. And so we have to look at Pickford. And I think it's important for us to go back and look at that timeline of dispossession, because in Pickford, there was $1 billion settlement. The USDA admitted to rampant discrimination within the agency, and only 4.8% of that settlement went to debt cancellation, only 4.8. And that's what has led us to this moment here, where only 3,100 out of the 22,000 farmers of color that are eligible for debt cancellation are Black. What happened to all of the farmers? And so what is revealed in the documentary, I'm Just a Layman for Justice, we also had a documentary film called Restoration, a concert film. And then we also had a series called Black Farms Stolen, the legacy of the Pickford lawsuit. And we were able to lift up the counter narrative, because the dominator narrative is that Pickford was restorative, but it wasn't. And that was the groundwork for the Justice for Black Farmers Act, the Emergency Relief for Farmers of Color Act, the American Rescue Plan Act, and now where we are, the Build Back Better Act. And so unfortunately, what has happened, and I want to make sure that I'm staying within my time, is that the story of deep-seated anti-Black racism became muddled. And there was another narrative that was lifted up, right? And so one of the issues that I want to put on the altar here for the community to really wrestle with is, why is it that this country does not have the political will or the courage or the desire to uproot anti-Black racism within the agency? Why did it take a viral pandemic for us to be able to push the issue of debt cancellation when our farmers have been fighting for debt cancellation since the disastrous implementation of the Pickford v. Glickman class action racial discrimination lawsuit? How is that possible? And then one of the issues that we talk about, because Our farmers have been fighting for justice in the courts for the last 22 years, and it never happened. It did not happen at the outset from the original egregious harm, which was the lawsuit that was supposed to restore them. One of the issues when we talk about the debt, it being a racialized tool, many of the farmers over the last 22 years, they have suffered under debt offsets. So USDA has actually offset their Social Security, their disability, their peanut subsidies, their tax returns. Elder Eddie Slaughter from Buena Vista, Georgia, double amputee, blind in one eye, talked about how USDA for 9 years offset his various peanut subsidy, disability payments amounting to $41,000. He only received $50,000 in the Pickford v. Glickman class action racial discrimination lawsuit, and he was still in debt $200,000. So now we're at this moment with the Build Back Better Act, and we can get into that later in the later part of the discussion of how to restore the Black farmer. And so one of the things that we realized is that we thought initially 17,000 Black farmers would receive debt cancellation. We were sadly mistaken. And that's when we realized the devastation of the Pickford v. Glickman class action racial discrimination lawsuit, because during the deliberations of the American Rescue Plan Act, we actually learned that only 2,500 Black farmers were eligible for debt cancellation and had debt with USDA. And that's out of 22,000 BIPOC farmers. And so with our advocacy with the Build Back Better Act, we were able to circumvent the frivolous lawsuits that I stopped counting at 12 in the various federal courts that were going to delay justice for our farmers. And so after the first one was filed, we immediately went back to budget reconciliation with the Build Back Better Act. And so what I want to leave the beloved community, again, in order for Black farmers to receive race-based remediation for decades of anti-Black racism, the remedy had to center white farmers, and white farmers had to get the lion's share of the debt cancellation. They had to get the lion's share. So one of the things that we were focused on, because we knew that only less than 8% of Black farmers would receive debt cancellation, is in the Build Back Better Act that's now in the Senate, we were able to secure language and allocation of at least $750 million in direct payments for farmers that have experienced USDA past and ongoing discrimination. And I think that when we look at movement lawyers, and Keisha's going to get into that, I think that there are various tools in our toolbox that we have to explore and use. Audrey Lloyd said you can't tear down the master's house with his tools, and we know that is true because our farmers have been fighting for over 30 years if we go back to President Ronald Reagan dismantling the Office of Civil Rights. And so I just wanted to leave and ground my final remarks in quotes from various light bearers that I carry and serve as containers for our work. One is a quote from Fannie Lou Hamer, and she said, "All I need is a pig and a garden and no one can push me around." Our ancestors and our Black farmers knew that, the sovereignty of owning land. Of course, the African proverb, the axe forgets what the tree remembers. Our Pickford legacy farmers are our trees, and we wouldn't even be here celebrating debt cancellation that would provide relief to BIPOC farmers and economically distressed white farmers without the suffering of Black farmers. And then the last quote is from Bernice Atchison, an elder farmer from Alabama. And she said she told her daughters, you have 2 feet to stand and 2 wings to fly. And I think that is the directive that we all have going into the work ahead of us. Thank you so much.
Hello, everyone. I am Keisha Stokesha, and I'm very grateful to be with you all today. I would like to thank my fellow panelists and moderator, as well as the Food Law and Policy Clinic for all of their work in support of Black farmers. In the spring of this year, Congress passed the American Rescue Plan Act. It was a major piece of legislation that did a number of important things. As discussed by my colleagues on the panel, Section 1005 of the American Rescue Plan Act provided one-time emergency debt relief or debt cancellation payments to socially disadvantaged farmers and ranchers. There's a long-standing definition of that term that does not exclude anyone by race, but applies to members of groups who, quote, have been subjected to racial or ethnic prejudice because of their identity as members of a group without regard to their individual qualities. In passing Section 1005, Congress recognized that socially disadvantaged farmers, and particularly Black farmers, have been disproportionately impacted by the economic effects of the COVID-19 pandemic. Yet, these farmers have been largely shut out of prior COVID-19 aid and relief programs for farmers. For instance, researchers found that white farmers received nearly 97% of $9.2 billion provided through USDA's Coronavirus Food Assistance Program, or CFAP, in 2020. In addition, Black farmers and minority farmers were already economically vulnerable due to decades of lending and aid discrimination within USDA. Without the emergency debt relief provided in Section 1005, many of these farmers would be unable to obtain additional lending to meet their farming needs this season. They face the loss of their small farms, family homes, and family businesses. Despite the necessity of Section 1005 to the continued viability of socially disadvantaged farmers and ranchers, who have been largely excluded from billions of dollars in prior COVID relief, the law was immediately challenged as racially discriminatory against white farmers in a series of federal lawsuits filed across the country. The Southern Poverty Law Center was approached in the summer to represent a coalition of farmers' advocacy organizations as amici curiae in the Section 1005 litigation to ensure that the perspectives of Black farmers and other socially disadvantaged farmers were heard. As USDA is the agency responsible for implementing Section 1005, the challenges to the statute were brought against USDA officials. But given USDA's own record of discrimination against minority farmers, there was concern that the agency could not adequately represent the interests of the farmers who would be most impacted by the litigation. At SPLC, we immediately recognized the importance of these cases to the direction of our country. As an organization, one of our impact areas is to eradicate poverty in the South. And we learned from the farmers and advocates that we spoke to that minority farmers across the South, the people responsible for putting food on many of our tables, are themselves living in poverty, teetering on the brink of financial insolvency and displacement due to decades of discrimination in federal farm lending and aid. These circumstances are a travesty of justice. These cases also implicate SPLC's dismantling white nationalism impact area. It is no secret that throughout our country's history, any effort to systematically redress racism and discrimination has been met with vociferous backlash and the accusation that the effort is tantamount to reverse discrimination against white people. This political maneuver of galvanizing resentment has been relied upon since Reconstruction, and it remains a potent and destructive force in our country today. It should come as no surprise then that some of the Section 1005 challenges originated with reactionary political organizations, including Stephen Miller's America First Legal. The Section 1005 litigation has resulted in multiple preliminary injunctions and one restraining order so far, which means that Black farmers are still waiting on the relief that they desperately need as the cases continue. While we are still in the early phases of this litigation, the cases have raised some important implications and questions for how we move forward as advocates seeking justice for Black farmers and racial justice overall. These cases have raised the notion of imposing strict time limits on Congress's ability to redress racial discrimination. For instance, one of the cases indicated that legislation may be deemed invalid if there is no proof of discrimination within the last 10 years. Rules like this would make it very difficult to redress discrimination that is generational. For instance, in the farming context, a Black farmer whose grandfather was denied a loan to expand the family farm 30 years ago for racially discriminatory reasons continues to be affected by that decision on his business that he inherited 30 years later. If the family stays in farming, the children and grandchildren will continue to be affected by the discriminatory act unless and until redress is made. A 10-year restriction on Congress's ability to redress discrimination will also foreclose reparations for slavery, race massacres, redlining, and other racial abuses perpetuated against Black Americans. The cases have also proven to be an important decision point for social justice lawyers. How do we advocate for fairness and justice in a legal context in which the federal judiciary has shifted decidedly rightward, at best reluctant, if not adverse to any effort to confront systemic racial discrimination in our country? For some, this has meant taking steps to prevent particularly consequential cases from reaching the higher courts if possible. For others who represent clients facing imminent, unavoidable harm, this has required litigating against long odds in unfavorable forums. But the Section 1005 cases also present an opportunity to educate the courts and the public about the ongoing harm of racial discrimination in our society and how it impacts us generationally and economically, even down to our food. Thank you.
Thank you all. You all raised some excellent points that I'd like to dig into a little further in the Q&A, but we're going to have to keep our comments brief because we're short on time. So I want to continue a little bit where you left off, Ms. Stokesha. I'm wondering if you have any sense of the timeline for these legal suits that have been filed to block debt cancellation to farmers of color.
Well, the cases are going to move forward at least into the next year. I think an intervention that could happen that would shorten the time frame is if the Build Back Better Act that Tracy talked about is passed by Congress and signed by the president and becomes law. At that point, I think the ongoing litigation against Section 1005 would be obviated and would go away. Otherwise, I think we can expect the cases to go forward in the trial courts, the lowest level federal courts, at least through next year. If appeals happen from there, then it could be a couple of years before those cases are resolved. And in the meantime, farmers are waiting on the relief that they desperately need.
Mm-hmm. And you touched on this just previously, but we're in a legal and a cultural climate right now that is very partisan and extremely divided. And I wonder, does that make these legal challenges to debt cancellation to farmers of color more difficult to deal with? And in what way has this climate affected the decision-making processes or the strategies of public interest lawyers who are dealing with or considering this type of litigation?
It has been very challenging for public interest lawyers because the implications are enormous. You know, I've talked about some of them, but we have whole structures in this country in terms of affirmative action, in terms of school desegregation cases that are still ongoing, that would be affected by a negative decision on Section 1005, for instance, that reaches the highest courts. I think we understand the weight of the cases, but at the same time, you have to balance that against farmers who are at risk of losing their family homes, family businesses, livelihoods imminently. So we can't not participate in these very important cases, and we have to deal with the courts that we have. I really see this as an opportunity as well for the public to understand the significance of decisions about who gets put on our courts. I think in this country, politically, conservatives have been very active in understanding the significance of the courts to them and why that should be a priority in terms of their voting and participation electorally. I think that's been less significant on the left in the country. And these cases can be a really stark example for the public to see, who makes decisions about what the Constitution allows can have direct impact on your family. And in these cases, Black farmers. And I think we really should raise that with the public so that they understand the significance of the courts and their decisions.
I would just like to pick up on that conversation thread as a movement attorney myself, and how we pursued, our entry point into this 25-year saga of our Black farmers advocating for debt cancellation was 3 years ago, when we learned that our elders were representing themselves pro se in federal court due to this disastrous implementation of the Pickford v. Glickman class action racial discrimination lawsuit. I think it's important for us to have this grounding that at the time of the consent decree, the Department of Justice invested 56,000 hours and $12 million fighting Black farmers on their claims. This is the Department of Justice representing the USDA. So I think that it can be very easy for us to slip into the conservative bent of the courts, and that's what has resulted in the erosion of the Black agricultural land base. But it's more fundamental than that. And so one of the things that a scholarship that I revisit often, my mentor, Cheryl Harris, Whiteness is Property. What we have to grapple with is, as a country, do we think that the descendants of enslaved Africans who are now citizens have a right to own land and to be protected? Because the courts have not done that, and the Congress has not had the will to do it unless it's packaged as BIPOC or it centers white farmers. And I think that's something that we really have to wrestle with. So I appreciate, Keisha, the zealous advocacy in the courts. But one of the farmers said, everything turns out Dred Scott for Black farmers, the Dred Scott decision. And I think there's truth in that.
I would like to add to this conversation. Depending on the courts, as conservative as they are, whether it's during a Democratic or Republican administration, depending on the courts, for me, as an advocate, is unacceptable. I believe in what should happen is that through the reconciliation process of the Congress, as well as the ability of Tom Vilsack and the Biden administration to move forward and make sure that these farmers that are suffering get the same relief and the same consideration as white farmers are getting today. So I'm not in agreement with waiting for the court system. We should demand, and we will continue to demand that the systemic problem at the U.S. Department of Agriculture, settling of cases of the thousands of Black farmers that are still in the process that had never been processed before, doing something about the county committee system, not waiting for an equity commission that takes us nowhere or takes us somewhere in 2023. These farmers and these employees need help, and they need help now. It is the responsibility of this administration that was elected on the backs of many Black people in this country. I say there's going to be a reckoning in 2022 and 2024 if Black farmers and this issue of Black farmers and racism at USDA cannot be dealt with in a positive way to get results, then I say that the Democratic Party and many of those running for office are going to be in jeopardy in the next voting cycles. That is my thinking.
You touched on two things that I want to come back to, and you mentioned this earlier as well. The equity commission that USDA is putting together. In fact, I believe the deadline for applicants closes today. They say that this commission is going to analyze how its programs, policies, and practices have contributed to and exacerbated systemic discrimination. Why are you not for this commission, or why do you not think that this is the answer that we need right now?
I really want to respond to that question. During the presidential campaign, our coalition, the Justice for Black Farmers group, met with the Biden-Harris transition team on numerous occasions. And at the time, the transition team, the ag policy was led by Secretary Thomas Vilsack. And we had numerous demands. Again, our coalition, we were talking about debt cancellation, a foreclosure moratorium, direct payments for Black farmers. And Secretary Thomas Vilsack countered with an equity commission. Those who study Black agrarian history, we can go back to 1965. There have been voluminous reports on anti-Black racism within the agency, the Farm Service agency, local offices, the county committee system. And so we see that as a very regressive posture. It does not invite transformative leadership or transformative change. And I think it's really also important to note that there were two reports that came out during 2016 and 2017 from the Minority Farmers and Ranchers Advisory Committee. These were reports that were given to Vilsack, recommendations on how to uproot institutional discrimination within the agency, and he did nothing with these reports. So I have a problem with the Equity Commission, and I see it as a way to obstruct and avoid immediate discussions regarding equity with respect to the Commodity Credit Corporation Fund and the abolishment of the county committee system.
I want to talk a little bit about the county committee system as well. When I speak with Black farmers, particularly Pigford legacy farmers, it's rare that the Farm Service Agency's county commission system is not mentioned. Could either Ms. Lloyd Mccurdy or Mr. Lucas, could you speak a little bit more to the purpose of these commissions, the role that they've played in perpetuating ongoing discrimination at USDA, and what you believe can be done to remedy this.
I think personally, the county committee system was put into place after Reconstruction during the Roosevelt New Deal. And it was put into place for one reason, and that is to protect the privilege. Make sure that Black farmers did not get the same consideration and programs that white farmers receive. Tom Vilsack, with the stroke of his pen, can immediately do something about changing that system that has been proven through documentation after documentation, report after report, going as far back as the DJ Miller report, and many other reports that have proven that the county committee system is a racist process that deny minority farmers, especially Black farmers, the same rights and privileges as white farmers. So my feeling is that we should not be waiting for an equity commission to do and come up with what we already know. We know that the Civil Rights 1965 document, and as well as in 1982, that talked about the commission report of what's going on at USDA. We know the Civil Rights Action Team report of February of 1997, and the follow-up a year later, the Civil Rights Implementation report, which was done in March of 1998. These are just some of the things and reports that have proven that the county committee system does not work. And we have an administration that is doing nothing about fixing that problem. The Jackson-Lewis report, Civil Rights Assessment in 2011, also said the same thing. The GAO and the OIG reports historically has identified the county committee system as a racist process that denied Black farmers and minority farmers their rights. I don't think there's any question about whether we should have this discussion about equity commission when the equity commission in the way we see it, is nothing but a commission to keep USDA from dealing with the problems they have and do it now in a systemic way. And I say that Tom Vilsack and the Biden administration and the secretary can, with the stroke of his pen, change things at USDA, including the county committee system, which we know is racist.
And I would like to get sort of a legal perspective on this. A major sticking point in the fight to block debt cancellation to farmers of color is the use of race-based language in Section 1005 in the American Rescue Plan. White farmers have used that to claim that they are being impacted by reverse racism. And we're seeing in attempts to remedy this or to push back against this, the use of race-neutral language. But how do we combat racism and discrimination without addressing race? Wondering if either Ms. Lloyd Mccurdy or Ms. Stokesha has any comments on this.
Well, I'll start. I think you can't effectively redress racial discrimination without using racial language. And this construct that's kind of coming out of these cases really places Black farmers, Black advocates, or people who care about Black people in a catch-22 situation. If you say anything about racial or ethnic, and it's to benefit minorities, then it's going to be treated by the courts with the highest level of scrutiny and skepticism, and they'll look for any justification to prevent the implementation of the statute. On the other hand, when it's discrimination that's being alleged by white people or white farmers, in this case, there's much less scrutiny of their claims or the validity of their claims of discrimination than is applied to Black people or minorities in any context. I think that Lawrence and Tracy have talked about the discrimination claims that are filed by minority farmers within USDA's apparatus and how those claims, regardless of their legitimacy and the documentation that the farmers provide, are routinely denied, at the administrative level. Discrimination claims by Black people and minorities are routinely denied and not given much consideration in the courts as well. But then you have these cases brought by white farmers. There's no allegation, and they're not required to allege that they would otherwise have been eligible for this legislation, or that the legislation prevents them from participation because they're white, because it doesn't. They don't even have to allege that they applied for the relief and were denied. None of the plaintiffs in the lawsuits actually applied and were denied the relief, but just based on if it mentions race at all, then that means that it should be invalidated. And any white person who is a farmer can bring any case like that. And so I think there is an asymmetry in treatment of discrimination when the person alleging it is white versus when the person alleging it is Black. It really does place minorities in a very difficult situation, which I think it's intended to be, where it's almost impossible to redress discrimination if you can't mention race at all.
And I just want to add, and it's so important for us to ground ourselves in this African proverb: until the lions have their own historians, the history of the hunt will always glorify the hunter. So when you look at the dominator narrative, you would look at this, the timeline, the historical timeline starts with the American Rescue Plan Act. But how did we get to this historical moment where 98% of the land is owned by European Americans, that they receive over 99% of the subsidies because it's based on acreage? And so they are prioritized and supported, whereas how this our federal government has been complicit. They have engaged in criminality to dispossess Black farmers of land. And so we miss, and if we don't study our history, then we don't look at the federal ag policies like the Homestead Act of 1862 that transferred over 240 million acres of land from indigenous nations to mostly white male settlers. And then with the Southern Homestead Act of 1866 that transferred over 46 million acres to mostly white male farmers. And so we're in that same colonial imaginary. I think it's really important. So when we even talk about the struggle of Black farmers and the fact that how we arrived here was from the Justice for Black Farmers Act, and we were trying to alleviate the suffering of Black, the Pigford legacy farmers that have been under this crushing debt for 22 years. Can you imagine? Actually, we go back to 1997, 25. But then even the dialogue, the discussion, we have to center whiteness instead of talking about what happened to the Black farmer back in 1997. And how do we go from 22,000 claimants to now only 3,500 that have existing debt with USDA? And the reality is USDA over the last 2 decades have foreclosed on Black farmers. And like grandmother Janie Bell Bembry, who again, transitioned to the land of the ancestors this year, her family back in 2011, they had to take out a private loan to pay USDA off because they had initiated foreclosure proceedings against her. She was a Pigford legacy farmer. She was discriminated against. She experienced the rot of anti-Black racism. But yet we're talking about reverse discrimination that is propaganda and perceived because it's not a benefit. Again, this is what Cheryl Harris talked about. When we discuss debt cancellation as a benefit, it is not. It's a right to rectify anti-Black racism and how debt was used as a sword of dispossession. There's a quote, and I don't know if I can pull it up right now. It's a quote, and I'll invite the group to look at it. I'll share it in the chat. But Toni Morrison talks about the politics of language. And that's why I think it's very important for us to ground ourselves in debt cancellation, not debt relief. Because when you go down the rabbit hole of debt relief, then you find yourself where the counter argument is reverse discrimination, and we're not talking about that. It's something more fundamental. Again, it goes back to the descendants of enslaved Africans. Can this country accept our sovereignty to acquire land and to leave wealth to the generations? And I don't think that this country has yet to get on the right side of history with that.
And what I would like to add to what my colleagues have said, I think when you take a look at the real history as to when and why these cases, approximately 12 or 13 around the country, was filed, we consider those cases, and I'll close, both frivolous as well as racist.
We have about 2 more minutes left. I'm going to quickly just touch back on something that was mentioned earlier, which was the Commodity Credit Corporation Fund. Ms. Mccurdy, you spoke about using that as an immediate remedy against the litigation that's halted debt cancellation. Could you explain what the Commodity Credit Corporation Fund is and why you believe this is a beneficial strategy?
Yeah, absolutely. So historically, the Commodity Credit Corporation Fund was created back in 1933, and it has been used over the decades to undergird and support mostly white farmers, corporate farms that grow commodity crops, engaged in monoculture agriculture. And actually, our coalition approached Secretary Thomas Vilsack about this very issue of looking at how the Commodity Credit Corporation could be used to restore the Black agricultural land base. And again, we noted how the Commodity Credit Corporation Fund was used by former President Donald Trump, and also President Joe Biden had talked about creating a carbon market to encourage regenerative agriculture and to pay farmers that sequester carbon. And so it was all this innovation around the Commodity Credit Corporation Fund. And so then our position is, we know that the vast majority, again, if we're talking equity, we know that the vast majority of this $30 billion fund that's inexhaustible, it's always replenished. How can we create a perpetual allocation for Black farmers to restore the Black agricultural land base? And we have asked Secretary Thomas Vilsack, the Senate Agriculture Committee, to engage in discussions around this. And instead, we get, and what we received before with the Biden-Harris transition team, is the formation of an equity commission. And so if you think about it, and if we need to do FOIAs to see how much money has flowed to white farmers under the Biden administration over the last year. And because it's based on acreage, the vast majority is still going to white farmers. And so it is our position that just how we use the budget reconciliation as a shield and a sword to eliminate economic suffering of the existing Black farmers that were able to hold on to their land, we are determined to do the same with the Commodity Credit Corporation Fund.
I really wish that we can continue, because this is a topic that we could discuss for hours and hours, but it looks like we're out of time, unfortunately. So I want to once again thank Harvard Law School's Food Law and Policy Clinic. I want to thank Mr. Lucas, Ms. Lloyd Mccurdy, and Ms. Stokes Huff, as well as all of you who took the time to listen. So thanks for joining.
Yes, thank you.
Thank you very much for having us.
Thank you.